Welcome to Legally Agile with Chris Werner.
Welcome to the first episode of Legally Agile, the podcast for founders and executives of high-growth companies who want legal strategy that keeps up with businesses. I'm your host, Evan Mack, and I'm here with attorney Chris Werner, founder of Vidar Law. Chris helps high-growth businesses navigate risks, seize opportunity, and stay legally agile without slowing momentum. In today's episode, we're talking about what happens where winging it on legal stops working. We'll look at the key legal foundations growing companies that actually need and how to put them in place without turning your business into bureaucracy. Chris, welcome, sir.
Thank you. Thank you very much. Thanks for having me.
Good to see you. Good to see you. So early months when a company is moving really fast, what does good chaos actually look like when the business is, getting its footing?
A lot of founders will tend to, as you said, wing it in their early days, and that's perfectly fine. What I tend to tell clients, especially if I talk to them very early, is, you don't want to spend a ton of money and a ton of time dialing in everything perfectly, things that you're going to need down the line. You don't need to get all that done. A lot of reason for that is, you may be pre-launch, you may not have a minimal product yet, you may not have any customers, and you're trying to get that stuff dialed in and figure out if your business is actually going to go. So wasting a lot of time with a lot of legal formalities is not good. What happens is you tend to use some DIY agreements. You tend to talk to your friends who are also starting up companies. You get some, there's a lot of resources online where you just pull sample contracts, agreements, things like that. And for the most part, I think that's fine. And I think that's what makes a lot of sense. Obviously, I think there's a few areas where you want to do things right away, even if you're not doing anything else. So for me, the three big areas are, number one, having an entity. That means either an LLC or a corporation. The reason for that is they protect your personal assets, right? You have a separate business entity from your personal assets. So it's important to have some sort of entity. For most early startup companies, early stage companies, you're probably going to do something in your home state, wherever you happen to be. And you're probably going to expect that entity is going to change, right? Like as your company grows, you will probably change. I like LLCs for very early stage companies because they don't require as many formalities and they're pretty easy to set up. Most states, you can go to the Secretary of State website, set those up within 20 minutes or less. The second thing that I think you need right away is, especially for a lot of the companies that I work with, is you want to make sure your intellectual property agreements are correct. So you want to make sure that among, if you're a solo, doesn't matter as much. But if there is more than one founder, you want to make sure that everybody is assigning the intellectual property to the company right away. That could be, a huge part of your business's value down the line. So you just want to get that done early. And then the third thing is, and this again is for multiple founders, right? So if you're by yourself, this isn't as important, but if you have multiple founders, you want to at least have something written down where you are talking to your co-founders about who gets what part of the company, and just make sure that's understood.
Well said. So even in that those phases, a few decisions can be left kind of vague. Which early fundamentals like that entity structure, equity, expectations, or that IP you were talking about tend to matter most for keeping a young company on solid ground?
Yeah, I would say, your most important things are going to be your agreements with your co-founders. That may not seem intuitive, right? You may think, well, I need to make sure I have an entity, that's the most important. And yes, it is important, but even more so your co-founders. I have seen many, many disputes that arise later when the money starts coming in that are a direct result of co-founders not being on the same page from the beginning. So I would say that those early agreements are definitely something you want to get done and make sure that everybody's on the same page early. Now, I say that doesn't necessarily mean that all of it has to be super formal, right?
Mhm.
You don't have to have everything perfectly dialed in at those early stages. You don't have to necessarily have, all of your vesting done perfectly. You don't have to have all of that. But if it's between you and I, right, and we're starting a company, I want to make sure that at the beginning, if I say I'm going to make the final decisions on things, so it's just the two of us, if we split it 50-50, we could end up deadlocked on decisions. And we've decided, hey, I'm going to make the decisions. So we want to make sure that this is written down early on, that as between you and I have 51, you have 49, right? And that may not be for every company, but you want to make sure that everybody understands that in the same way.
Have you seen a situation where something small in those early decisions later created that friction or that real cost once the business scaled and got bigger?
Several years ago, I had a client. They were in the healthcare tech field, and it was a husband and wife who were running the company.
Mm,
Um, because of that relationship, they left a lot of this equity very, very informal, and they operated that way. Which is fine as long as everything's fine. About a year and a half into it, though, things did not go as well, and there was a huge dispute. Now, maybe the company would have, fallen apart just because of that, but there was a lot of value still there. But the dispute between the founders essentially destroyed any value that they could have gotten out of it.
mm,
And so not getting that right, you and I might be best friends, right? We may have grown up together. We may have known each other since we were, little kids growing up on the same street, right? And we may be perfectly aligned. But when the money rolls in, when hard business decisions have to happen, if we're not on the same page on how those decisions get made, who owns what, when it's time to get paid out, you and I start fighting, out of nowhere. We've never had a crossword in our life, and all of a sudden, there it is. Now, if we're on the same page from the beginning, we just don't ever have that dispute.
we're talking about growth, and as a company grows, those certain moments that signal that improvising isn't enough anymore. What kind of milestones usually indicate that a business has outgrown that whole concept of winging it?
I've given this a lot of thought over the years. There's no set formula necessarily for it, but I think there's a couple of real indicators that it's time to start putting some more formality around it. Number
Mm,
one is when you start taking in outside investors. Sometimes they will insist on more formality, but sometimes they won't. And even if they don't, when you start taking in their money, you want to make sure that you're getting this right. So one reason for that is your outside investors probably have more money than you do. Um, and if you get into a dispute with them, they are going to have more money to litigate with you, and sort of bury you. So you want to make sure that formality is there, even if they're not insisting on it from the very start. Um, the second big milestone is if you are starting to hire some early key employees, and especially if those employees are going to be granted equity options as part of their compensation package, which is very, very common. At that point, you've got to make sure that you've got some formality around your option pool and how that is going to work. It's also a great time for the co-founders to get together and talk about what that's going to mean for their equity down the line as they
mm,
start granting these options. And then the third big thing is if you've got a product and you start selling to an enterprise level client. So, if I'm selling something to, another really small company, not quite as important. But if I start selling to a large enterprise style client, you want to make sure that formality is there. In that case, it's much more of your contracting process, and your internal controls are going to be a lot more important. But those three things, investment, key employees especially with equity options, and when you sign your first big enterprise client, those things tell you it's time to get a little more formal with how you're operating.
And once that the company hits that milestone, where do you tend to see that avoidable risk show up? Especially around those contracts, and you were talking about the DIY document or terms that never are properly standardized.
I've done this quite often with clients, is they will start a lot of DIY in their early stages, and they'll come to me when they're ready to get more formal. And so what we tend to do is we do an early triage, and we start to line up all the corporate documents. So
Mhm.
especially if they've changed their entity or had a lot of DIY stuff, what they don't realize, and they shouldn't be spending their time on this, that's my job, is that the terms within those different agreements don't always match up. So um, one co-founder may have a vesting schedule that's different from another one. That's okay. But those two agreements may not match your cap table. And when you change your entity to, let's say, a Delaware corporation from a state LLC, if you put those together yourself, those documents that you filed with the state may not match your private agreements on equity internally. So that's a big risk that we can avoid, and it's easy to catch if we do it early. It's easy for us to get our hands around it, make amendments that we need to, and sort of get that dialed in. The other big thing is, I touched on enterprise level clients. Those clients are going to be sophisticated. They tend to have their own in-house general counsel.
Mm.
A lot of times it's a large team of in-house lawyers. So their agreements are going to have lots and lots of terms in them. And I have seen clients and had to help dig out of these things where they sign those initial agreements because they want that thing signed up, and they haven't looked carefully at them. And there's something in those agreements that obligates them to do something they didn't realize. And when that happens, they either have to eat the cost of doing that additional thing, which they
Mm.
didn't expect, or they have to try to renegotiate, which leaves them in a position of upsetting, sort of their first big client. Sometimes it's fixable, sometimes it's not. So if I can get involved at those stages, I can prevent those problems from coming up, 6 months, a year down the line, when it's going to be harder to solve.
You wouldn't know by looking at you, but you've been spending more than 2 decades working on this stuff. You know what I mean? Both disputes and deals. How does moving between those two worlds kind of shape the way like you guide these fast growing companies?
I took a very winding path to get where I am today. So I started my career at a very large law firm, working in commercial litigation, and I was representing, Fortune 100 companies in those disputes. So my mindset when I started was to see all the problems that can occur. And I tell clients a lot of times, hey, if you think you're making a mistake, don't be embarrassed about that, because I've seen some of the largest companies in the world do some very dumb things.
Mhm.
So it's given me a perspective on how to avoid those disputes. And then I sort of took that experience and started representing, entrepreneurs and startups and fast growing companies. And that took a while for me to learn that new skill of how entrepreneurs operate and how they think, because
Mm.
my early training was all risk avoidance. Avoid every bit of risk you can. As I started doing more of work with entrepreneurs, the way my thinking started to evolve was, let's analyze the risk. Let's let's try to quantify what that means, and then let's have a discussion about what risks are worth taking and what risks are not. So this kind of goes back to some of your earlier questions of sort of DIY early stages and being very chaotic. That makes a lot of sense. Now, you go to me when I was in, my early corporate, attorney life, and I would have said, "Wow, you got all this risk. This is terrible. This is terrible." It's not terrible. It's actually what you have to do. So sort of walking between these worlds has allowed me to sort of appreciate, okay, here's the risk over here. Here's what we need to do in order to avoid that risk. And that is really going to pay dividends for the clients going forward.
So, Chris, for a founder planning ahead for that next quarter, what are a few practical actions they can that can meaningfully strengthen their legal foundation without disrupting that day-to-day operation?
Yeah, so I think there's a couple of things that they want to do depending on where they are in the journey of their company. I would say, if you're very early and you haven't put together a business entity yet, you want to do that. I would also recommend talking to an accountant right away and making sure you've got that dialed in. If you're a little farther along and you're looking at what's going to go on in the next year, the next 2 years, you should probably start thinking about developing a relationship with an attorney who can help guide you going forward into the next year. This is really true if you're thinking about fundraising. You want to start early developing that relationship, and give yourself enough time for your legal team to do triage, to evaluate what's going on, and sort of fix the major leaks that you may have, and then also sort of help you map out where you're going in the future. So I have a client who is in that stage. They're growing. They're planning on taking funds, and we've done a lot of triage with them of let's get you ready to go. And this doesn't have to be disruptive. Especially if you are small, you can handle this stuff with minimal disruption if you attack it early. What I try to do is make sure that I'm sort of thinking through what those next steps are, so that the businesses and the business leaders don't need to be worrying about those sorts of things. Like, that's my job to worry about, getting that done. So
Good stuff. Chris, thank you so much for your time.
Hey, thanks a lot.
Awesome. And thank you all for listening to Legally Agile with Chris Werner. If today's conversation sparked questions about your own company, whether it's legal foundations, disputes, or getting the deal ready, you can find more resources at vidarlaw.com/podcast. There you will find short form and long form kind of content if you'd like to explore working with Chris and Vidar Law for your high growth business. If you found this episode helpful, please follow the show and share it with another founder or executive who would benefit. We'll see you in the next episode. Thank you so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.